Hello and welcome back to my YouTube channel Legal Information, Law Insights. I am Advocate Mukund Mahajan, and today we are diving into the Indian Succession Act, 1925, a comprehensive law that governs inheritance and the distribution of property in India. Whether you are drafting a will or wondering what happens if someone dies without one, this video will provide the clarity you need. In this video, we will explore the key provisions of the Indian Succession Act, 1925, which govern the laws of inheritance, wills, and the distribution of estates in India. Let's get started. Now, we will discuss the applicability of the Indian Succession Act, 1925, and its relevance to various personal and religious laws in India. The Indian Succession Act, 1925, applies to most Indian citizens, but with some exceptions based on religion. Here's how it breaks down. Hindus, Sikhs, Jains, and Buddhists primarily follow the Hindu Succession Act, 1956, for inheritance. Muslims are governed by personal laws based on Shariat. Christians, Parsis, and Jews are covered under the Indian Succession Act for both wills and intestate succession. It is important to note that the Act applies to Christians and Parsis, with limited overlap with Hindu and Muslim personal laws, particularly in matters of wills and probate. Now, we will discuss testamentary succession under the Indian Succession Act, 1925, focusing on the legal aspects of making and executing valid wills. Let's talk about testamentary succession. This refers to inheritance through a valid will. Creating a will ensures your property is distributed according to your wishes after your lifetime. Here are the essentials for a valid will under Section 63 of the Act. First, the will must be in writing. Second, it must be signed by the person making it, called the testator, and third, it must be witnessed by at least two individuals, who must also sign the will. Other important points to remember include revocation of will and probate of will are: A will can be revoked or altered by the testator at any time before their death. In states like Maharashtra, West Bengal, and Tamil Nadu, probate, a legal validation of the will, is mandatory. Now, we will see what intestate succession is under the Indian Succession Act, 1925, which governs the distribution of a person's estate when no valid will exists. Let us understand what happens if someone dies without leaving a valid will. This is called intestate succession. The rules vary based on the deceased's religion. For Hindus, Sikhs, Jains, and Buddhists, the Hindu Succession Act, 1956, applies. Let's break it down. If a Hindu male dies intestate, his property is distributed in the following order. Class 1 heirs, the property is distributed equally among the widow, sons, daughters, and mother. Class 2 heirs, if there are no Class 1 heirs, the property passes to the father, siblings, nephews, and nieces in a specified order. Agnates and cognates, if no Class 1 or Class 2 heirs exist, the property is inherited by agnates, relatives through the male line, and then by cognates, relatives through the female line, and government, if no heirs are found, the property escheats to the government. For a Hindu female, the rules differ slightly. Her property devolves in the manner is distributed in the order. First, the property is shared equally among the sons, daughters, and husband, and second, if no children exist, the property passes to the heirs of her husband. Third, if neither of the above applies, the property goes to her parents, and if they are not alive, it passes to the heirs of her father and then to the heirs of her mother, in that order. Now, we will explore some special provisions under the Indian Succession Act, 1925. First, for adopted children. They are treated as biological children for inheritance purposes. Second, step relations. Not recognized unless legally adopted, and third, conversion. Converts can inherit, but restrictions may apply depending on the circumstances. To understand the probate of a will and the administration of estates, we explore the legal process of validating a will and managing the distribution of assets and settlement of debts. Probate of a will is the legal process through which a court validates the will's authenticity, and the estate is administered by the appointed executor, who is responsible for distributing the assets and settling debts as per the will. Probate is a crucial legal process that validates a will. It is a court-issued document confirming the authenticity of the will and authorizing the executor to distribute the property. In the absence of a will, letters of administration are issued, appointing someone to manage the estate, settle any debts, and then distribute the property. Now, we will understand the protection of rights under the Indian Succession Act. The Indian Succession Act safeguards the rights of dependents, including minors, widows, and elderly parents. For instance, a widow retains her share of the property even if she remarries. Minors' inheritance is protected until they reach adulthood, and dependents are entitled to maintenance from the estate. The Indian Succession Act, 1925, is a vital framework that ensures fairness in inheritance while respecting the wishes of the deceased. If you have any questions or need legal advice, feel free to leave a comment below. Don't forget to like, share, and subscribe to Legal Information, Law Insights for more legal tips and insights. Thank you for watching, and we will meet again in the next video soon.